And I think we should be off. Let me just test the audio. All right, so good evening, or depending on when you're watching this, if it's at some other time, good morning. I am doing my bi-monthly webinar today, which is December 10, 2020. The second part of my top 10 tips for men filing divorce over 50, how to handle a silver divorce. My name is Brad Micklin. I'm the attorney and managing member of the Micklin Law Group, which is a law firm concentrated in empowering men and fathers in divorce and custody and family law matters, with offices in Nutley and Montclair, New Jersey. Today is the second part of my series. The first one can be found on my YouTube page from October 12, 2020. I decided to terminate that one a little early because I thought it was just going to be way too long. Tonight's webinar probably much shorter since it's not really the second half of the material, but really like a quarter of it. The webinar, as all my webinars, are intended to be 60 minutes, give or take, and never know how long it's actually going to be. I will remain afterwards for any questions that any viewers may have, both on YouTube or my GoToWebinar, or into Facebook. If anybody pops in, I'm simultaneously broadcasting this on my Facebook page. It's a one-way communication, so you can't just ask me a question, but you can post it in the chat panel, which you should have on the right panel that it should appear on your screen. Under where it says questions, just tab it in there, write it. I usually recommend you do it while we are doing or broadcasting the webinar so that you don't forget and I can make sure to get to it afterwards. I will stay as long as it takes. So let's just jump right into it. Let me do a quick sound check. I'm using new technology and everything's new with working from home and all the COVID-19 changes. But so I got obviously new computers and microphones, hopefully improving the audio, but can somebody just respond to let me know that you can hear and see my presentation? You can't see me. I had originally put that on, but the lighting was just poor. So, all right, so it looks like people can hear me. I'm actually also going to quickly attach the PowerPoint from my desktop, so that any references that you're interested in having regarding cases or citation to statutes, you can just download it from the YouTube page. So that is up there. So let's go into it. All right, so where we left off was considering prenuptial agreements for a subsequent marriage. Now, I know everybody, oh, my beautiful wife just walked in, ironically, as I'm doing a divorce seminar. Let me just pause this for a second, guys. I'll be right back with you. Oh, and then she's gone. All right, so it's always nice to have a visit. Let me just go back. So I know everybody that's getting divorced, not everybody, but most people will say things like, oh, never again. And that's quite common, but it's also common to remarry. It's just based on fate. So if you are going to get married, even later in life where you think things are, established, you understand it, your assets are premarital and protected, still some things you want to consider. If you are considering a prenuptial agreement for a second marriage, you've also already gone through a divorce, you understand how expensive and draining it can be, both emotionally and physically. Most people are not going to do it again. And if they are going to do it again, they are likely to require a prenuptial agreement. You can also, no, I didn't put this into the materials, but there's also something called a postnuptial agreement, which I think I've done a webinar on that before. I have to check. If not, I will consider doing one. You can do after you're married, but I think a prenuptial is better. Currently, the law favors that over a postnuptial. Well, there's been a lot of changes in the laws about prenuptials. The average opinion on a prenuptial is that they don't get upheld. That's an archaic view. In the past, may have been largely true, but now it's not. The law used to say that a prenup needed to be fair at the time it was being enforced, which is at the divorce, not at the time it was signed. And that created a really confusing sort of catch-22 for people, because most prenuptials were unfair later. You signed a prenup, 10, 20, 30 years when things were drastically different. And then you had circumstances change, you had changes in education and work experience, and people were making much more. And agreements were being deemed unfair because it was a hardship to the person who had signed the other end of it. So it made prenuptials almost pointless because circumstances always changed. And the reason you entered a prenup was because you anticipated things to change. So now it used to be it was enforced if it was fair at the time of the divorce. Now it's enforced if it was fair at the time that it was signed. And now I'm not going to go into the great details about that. I know I did a webinar on prenuptial agreements, so I'd rather you go and watch that at a separate time so I can just get through this material. Here is the citation for the changes regarding prenuptial agreements in the divorce and alimony statutes. It's NJSA 37:2-31. You might want to jot that down if you're not going to download this information, because it is a serious, significant change, even for people that are not doing a prenup now. If you happen to be getting divorced and you have a prenup, this law won't apply to you, assuming it wasn't drafted in 2014 or after. It only applies to the changes in the alimony statute from 2014 on. Moving on to another significant issue when looking at a silver divorce, which, by the way, I don't know if I introduced that on my YouTube the webinar when I started. I think I did, this being the second part of my top 10 tips for men divorcing over 50, how to survive a silver divorce. Plan ahead for life and health insurance needs. Always a big issue in divorces, but much more significant when you are over 50 and getting divorced. So you need to consider, first of all, yours and possibly your spouse's need for health insurance or Medicaid. Health insurance is challenging when you are getting to a moderately advanced age, and if you are currently receiving insurance from your prior spouse, you may have difficulty affording insurance once you are divorced. Medicaid may or may not be, or Medicare may or may not be an issue. I guess Medicaid also, but not really inside of the purpose of this video. So you want to discuss with your attorney, assuming you have an attorney, what your life insurance needs also will be. If there is going to be an alimony component or a child support component, which we'll get into later, there will typically be life insurance needs. That may be very challenging and expensive to obtain in a divorce. So you may want to gauge what your needs will be, your level of insurance, so that you can price it before you resolve the divorce or before you go to trial, because it's going to be a significant amount of money if you have a large life insurance need. Health insurance may also be significant from a cost standpoint, but you can price shop that also. As my PowerPoint mentions, it's challenging to get as we get to advanced ages. Now, there's something I didn't cover in here called a divorce from bed and board, which is also called a limited divorce. This is a divorce that does not completely sever your marital contract. Instead, it allows you to resolve all the issues of your divorce on the financial and child issues, but still legally remain married. Now, again, I won't go into this at length, and I'll consider another video on this too, because it's a common topic. But people that typically use divorce from bed and board are using either because they have religious restrictions that prohibit them or restrain them from getting divorced, or because they hope to stay on their spouse's health or life insurance policy. I guess really health, not life. Life you can always remain on. But you can stay on the health insurance policies, because when you get divorced from bed and board, you are still legally married. When you get divorced, you cannot be considered a family member, and most insurance policies do not allow you to continue covering non-family members, health insurance policies. So a lot of people started using divorce from bed and board as a way to stay on their spouse's health insurance. Now, insurance companies got wind of this, and they started to deny people coverage for health insurance after a divorce from bed and board. Some allow it, but here's the caveat. The insurance companies that allow it can change their policies in the future. So if you are getting divorced from bed and board and you are providing for one of the parties to remain on the other party's health insurance based on the insurance company's indication that they do cover it. You need to have language that protects you if you're the one receiving the health insurance in the event the insurance company changes its policies later and you cannot continue to be covered. You need to be able to re-examine possibly the settlement. You may have to re-examine the alimony obligations, life insurance, whatever it may be. There should be language that protects you from losing that coverage in the future. It's probably a significant provision inside of any settlement agreement. Next, we move on to inheritances. Inheritances can often be a significant issue in the division of assets in a divorce. As the spouses advance in age, obviously so do their parents, and a lot of divorcing people find they have parents in 70s, 80s, 90s years old, and there could be insurances or inheritance coming. First, you have to understand that an inheritance is generally going to be exempt from the divorce as an asset. Unless the inheritance is going to both spouses, it's going to be exempt as a marital asset. But the receipt of an inheritance can be used to determine or influence the analysis of a person's ability to pay alimony or their need for receipt of it. So if you are or your spouse may be receiving a substantial inheritance in the near future, you may want to consider how that should impact alimony and child support obligations, even if it's in the future, or even if you just include language that provides for a review in the event that somebody does receive a significant inheritance or any other significant change in financial circumstances. You also want to consider the estate planning, the elective share, a very complicated issue that I won't go into at length here. But what's important about estate planning when it comes to divorcing, as my next slide should show, is when you file a divorce, your will, if you had one, is automatically revoked. So first thing is you need to draft a new one. And I advise my clients early into the divorce process to do another one. There's also something called the elective share, which was mentioned on the earlier slide, which allows a spouse who is omitted from the will to claim 1/3 of the probate assets if he or she was left out of his or her spouse's will. Now, it's a topic way too complicated to go into in the middle of this webinar, but you do want to understand how that impacts your current estate plan while you're getting divorced and your divorce settlement as far as your future obligations and how you draft a will after your divorce is filed or you get divorced. Inside of this planning, you also need to plan for your fiduciaries or the people that will both handle the probate of your estate as well as the assets that may be divided or that remain for children or even your ex-spouse. And healthcare representatives, again, it's just a side note for estate planning as and I always say we because I'm advancing in age too. Those who are watching the webinar may not see I'm 50 now. Just turned 50 this year. So silver divorces would be a topic in mine. I got divorced first time in my 30s, not doing that again, meaning I got remarried, obviously, because my wife popped in before, but I'm not divorcing her. Hopefully she won't divorce me. So another issue is the marital residence. Now, this is always a significant issue in divorces, but I think it's more significant in a silver divorce because there's more often a greater amount of equity, a large increase in the value of the house, assuming, historically people moved into house, stayed in the house. There's going to be some considerations anybody's going to have when it comes to maintaining or selling the marital residence. Obviously, here I list a few. Some families, both before they're divorced, look to downsize, the sort of empty nest syndrome, children, out of the house, and you have a lot of space that you may not need anymore. Conversely, however, you may have children that are still in school, and it may be important that you need to keep them in school districts. You might want to keep their lives stable and their friends and everything they know consistent. And you may not want to start over. And usually there's one spouse that is desirous of maintaining the former marital residence. For whatever reason, it's often less expensive. There's no tax consequence to the transfer. There's usually no tax consequence, capital gains to the sale. So sometimes it's worth holding on to. if there is significant equity in a marital residence, you certainly want to take that into account when you are dividing your assets and your debts. As all assets and debts get divided, it's significant to consider the tax consequences both now and in the future. And if one asset has a greater tax consequence than the other, you certainly want to take that into account so that you get the fair end of both the assets you keep as far and as well as the ones you give away. Now, much to my surprise, that's actually the end of this webinar. I thought when I did the first one in October that I was stopping sort of midpoint, but I really didn't calculate it because I was hoping to get through the information. And instead, I just stopped when I got through the first webinar to the length where I thought people might start to lose interest in watching it. So I stopped it there, not realizing this one would be so short in comparison. It's maybe 20 minutes in length. I will stay online, as I said, and see if I got any questions. Let me check on Facebook to see if anybody's signing on. I got any questions? I don't see any there. Let me check my page here. Well, let me real quick also see if, no, it doesn't have my contact information. So anybody who's watching this now or in the future, obviously, you can go to my website, which is micklinlawgroup.com, MICKLIN lawgroup.com, all one word, to get information about how to meet with me, how to get some information from our websites. I have a YouTube page, Brad Micklin, with a significant amount of resources for men and fathers in divorce and family law matters. I recommend that you go there and subscribe if you're watching this webinar, because obviously these topics apply to you. That way you'll get notices when I go online, and you can also comment about my information and the materials. I don't see any, there's us in case I don't see any questions. I will hang on for another minute. Again, surprisingly, this is not as long as I thought it would be, so I don't know if that's good or bad. But hopefully this information helps you. Like I said in the beginning, go back to my October 12 webinar for the first part of this information. It's much more thorough and lengthy than this one is. And then this was just kind of how to wrap it up and tie up any loose ends you may have. Hope the information helps you. Hope you're staying safe. Have great holidays, and I will see you next time I'm online. Good night, everyone.